Hi, Miss Everett. Hi, Miss Everett. Can you hear me?
Because it's not our fault. We definitely been paying and they was
Good afternoon.
Good afternoon.
Are we ready on Park Estates versus Harris and Park Estates versus Singleton?
Go into a breakout room, Your Honor. I'd be happy to,
Absolutely.
become a co-host if you'd like again, whatever's easiest. Thank you.
Ms. Harris? There we are. Good afternoon, Ms. Everett.
Good afternoon, Judge.
How are you, ma'am?
I'm well, and yourself?
I'm wonderful, thank you.
Good.
If this wind would die down just a little bit.
Well, you know, it could be with some white stuff going with it, so I'm gonna take it.
I saw a little bit of that, but I'm not gonna complain.
Nope, don't, because it can get worse. We are in Michigan.
I know.
So is it just me and you right now?
My secretary's here and we're streaming on YouTube.
Oh, okay. Well, I'm back muted, so you can do something and I can too until my turn is called.
Because I show you at 1:30 with the Metro Commons case, correct?
That is correct. So yeah, if I don't do it early, I'll forget and then I'll get fussed at. So
Understood.
I just put it on mute, get my work done, and hope I remember not to stray too far away from the phone.
Thank you, ma'am.
You're welcome. Have a good day.
You too.
Thanks.
Judge Martin, I just wanted to let you know that both clients are here with me, so they won't be signing in separately.
Absolutely. This is 223390 LT Park Estates versus Arnold Harris and Victoria Harris. May I have your appearances, please?
Jeremy Marks appearing on behalf of the plaintiff.
And Tabitha Harris appearing on behalf of the defendants, and they are here, Arnold and Victoria Harris. Did you need them to actually come up and speak, Your Honor?
No,
Okay.
ma'am. Thank you, though. Today is the day and time set for the adjourned hearing in this matter. The court had entered an order yesterday from our last motion day. The clerks will mail out copies when the file gets back downstairs. How are we proceeding this afternoon, Mr. Marks?
Your Honor, we are close to settling and resolving this. We would request a 2-week adjournment for another hearing. And hopefully by that time, everything will be resolved. Unless Ms. Harris disagrees, I don't think we need to set any further hearings for a potential jury trial or anything like that at this point.
That's correct, Your Honor.
Thank you. If you're close and you're looking for more of a control date, do you want to put it back on that December 12th date that we were scheduling things earlier, Mr. Marks?
I think that would be appropriate, Your Honor, an actual
Are you-
hearing date. Yeah.
Are you available that day, Ms. Harris?
And I'm sorry, what date was that, Your Honor?
Monday, December 12th, at thinking 10:30?
Just give me 1 second, Your Honor. Let me just look at my
Absolutely.
calendar. Because if I go by my memory, Your Honor, it won't be good.
I know, best laid plans that you'll remember to do something, yeah.
Okay, and then, okay. One more calendar, Your Honor, because I check my work calendar as well. Let's see. And you said that was the 12th, Your Honor?
Yes, ma'am.
It's gonna be on Zoom, is that correct?
Yes, ma'am.
Okay, I
Unless
should
you
be
wanna
able.
in person.
Okay, well, no, it would be, if it had to be in person, Your Honor, I would have to get another date because I have a meeting that day, but I'll be able to like break away and do that and do the Zoom. That'd be fine.
We'll adjourn the hearing to December 12th, 2022 at 10:30 a.m. back on Zoom with me. And then we have 223388 LT. This is Park Estates versus Laura Singleton and Carl Singleton. I'll note your appearances for the record. The parties had an opportunity to speak in this matter. Mr. Marks, how are we proceeding in this case?
Similar to the last hearing, Your Honor would be requesting a 2-week adjournment in order to hopefully finalize everything and resolve the case.
We'll put it over to that same date and time, December 12th, 2022 at 10:30 a.m. back here with me on Zoom. And number one, as always, if you resolve before then and you execute some kind of consent settlement agreement, whatever it is, just send it over and we'll get it signed and get you off of the docket. You won't need to appear. Anything else this afternoon in these matters, Mr. Marks?
No, Your Honor.
Anything else, Ms. Harris?
The only thing I think I had mentioned to Mr. Marks, Your Honor, you may not have, I did forward some leases over that I had from, because my parents were actually, I forwarded the original lease and then the courtesy leases that they gave me. And I think that there was being held in abeyance the issue of the money payments. But I will say that we were in a breakout room and it does look like they have a community manager there Monday through Friday, and she's willing to accept payments in the office.
I printed out the fully executed lease and put it in the file. I saw the courtesy copies, but because they did not appear to be fully executed by all parties, I didn't think that they would be, bless you, sir. I didn't print those out because I didn't want 4 copies of the lease that would confuse people. If you and Mr. Marks and the property are able to work out the details on the payments, that's something you can include in your settlement or just keep it between yourselves.
Thank you, Your
But
Honor.
thank you for sending that over, ma'am. I'll see you on the 12th, Ms. Harris.
Okay, thank you, Your Honor.
You're welcome,
Thank you.
ma'am. To the gentleman with the blue shirt on, your name, please, sir?
Lloyd Evans.
Mr. Evans, the attorney is here from Metro Commons. Do you need a moment to speak with him, sir?
Yes.
Mr. Evans, you're going to see an invitation.
Your Honor, I don't mean to interrupt you. This case isn't set till 1:30. And I'd like to provide enough time for my client to log in. And
She's
they'll,
here.
Oh,
Ms. Everett's here. That's the only reason why I said something.
I'm so sorry. And I also had a question. So whenever pertaining to a related case that we just did, but a different one, but just I had an off the record question for you. If you'd like to do that now, since we're a little earlier after we do the Evans hearing.
Well, we'll do is Marion will move you into a breakout room and I'll go somewhere where I can hear your question.
Okay.
Thank you.
Mr. Marks, do you just want to go back into room 1 and the judge will join you there?
That works perfectly.
Thank you.
Marianne,
Yes.
you're sending me the invitation because I was renamed as Lloyd Evans instead of the RCT number.
Okay. How did that happen?
I don't know. That's a Wednesday move.
Well, that had to have been me because I'm the one who renamed them.
I wasn't gonna say that.
Thank you.
I don't know if you heard Ken say it earlier, but they had to actually drill this clock into place.
Oh, no, I didn't hear that. That's not coming down for a while.
That thing has fallen off the wall 4 times. And if it had been $100 clock, it would have been shattered into a million pieces. But the little $18 special doesn't even have a scratch on it. So by the time I got downstairs before lunch, Sandy had already disposed the files and had printed out the notices for the cases with return dates.
Wow, that's incredible. That's cool. How did she feel about it? I mean, was she good with that?
Yes. And I
That's
think it
all.
helped that this was a relatively short second hearing docket.
Right.
Have you been outside?
No, I have not.
That wind is worse than it sounds.
Yeah, and I can see the light pole in the parking lot really moving. Like big time. And I didn't realize it was gonna be this windy and I asked my Alexa this morning and they said a wind advisory till 10 tonight. Is
When
it
I
hard to
stopped at the
drive?
light- It was difficult.
Ooh,
When I stopped at the light at Wayne and Goddard, a big gust picked up and it looked like this parade of leaves were marching across the intersection. The car was rocking a little bit. So we have another jury date. I think I'm going to set January 20th. We already, well, not set, but we already have I think it's a civil infraction scheduled that day.
January 20th, we already have a jury trial.
I know,
Oh,
but it's a civil infraction. I'm thinking
Oh.
of setting a second case on that day is what I'm saying. And
I see what you're saying. Okay.
because if you look at what we have scheduled, I just hate to have a whole panel come in for what should resolve. Oh, excuse me. I don't know. I just don't have a next date in mind.
Turn the video off. While I'm on there looking crazy. I know that judge probably like, "Ooh."
Good afternoon.
Hello.
Your name, please?
Man.
Thank you. I have not seen your attorneys just yet. If you would mute yourself.
Okay, thank you.
Thank you very much.
Well, I didn't hear what, to rename, I didn't hear what their name was.
The Bowman file, the 145.
Thank you.
You're welcome. Mr. Brewer, do you need to speak to your client, sir?
Good afternoon. No, we do not. We're all good.
Okay. This is 223088LT. This is Metro Commons versus Lloyd Evans Jr. and Jeannie Finley. May I have your appearances, please?
Jeremy Marks appearing on behalf of the plaintiff, Your Honor.
Lloyd Evans.
Jenny Finley.
Thank you. Today is the day and time set for the adjourned hearing in this matter. The parties have had an opportunity to speak. Mr. Marks, how are we proceeding this afternoon?
Yes, and thank you, Your Honor. I've had an opportunity to speak with the defendants and with my client. We'd be willing to adjourn this case for 2 weeks in order for the defendants to get their Sarah, hopefully get their Sarah payments and come to a paid in full at that by that time.
I thought that's what was happening. The last time we adjourned it, I thought there was just shy of $4,800 in Sarah funding coming.
Yeah, I would. That's true. Miss Finley let me know that I think the check was cut improperly, so it had to be recut, and now there's a second Sarah amount approved that they're waiting on, and my client has graciously, agreed to an adjournment in order to see if those funds could be funded and get to my client. And also Mr. Evans also indicated his willingness to pay a substantial amount in order to hopefully come current. I just want to let Miss Finley and Mr. Evans know that December rent is due tomorrow too. So that's obviously that's part that will, the balances that I gave you are as of today, which is in November. Just let you know.
Correct.
The court will adjourn the case. Our next date that we're using for some second hearings is December the 12th at 10:45, back here on this same Zoom with me. My concern, Mr. Marks, is that when we were here on November 15th, the balance was just shy of $11,000. And even with the $4,800 coming from Sarah, that still is a substantial balance. And parties considering adding the December rent tomorrow, we're talking about quite a bit of money. So Mr. Evans and Ms. Finley, when we come back on the 12th, please be prepared to resolve this matter in its entirety, okay?
We will not be
Yes,
seeking
Your Honor.
additional. I'm sorry, I didn't mean to interrupt you. Very sorry.
I was just saying that, Your Honor, that we were also approved for a second half of the Sarah as well. So that's probably what you're not saying, because the day that we came to court the last time on the 15th, the day after we were approved for a second half of the Sarah for another 4,300, 4,333. And we were going to pay the difference from that. We've been reaching out to Metro Commons as well as Wayne Metro, and that's how we came to this conclusion that we were going to pay the difference of the two approvals that we have.
Thank you, Mr. Evans, for clarifying that for me. I will see you here on December 12th at 10:45 a.m. unless the parties resolve it and submit a signed document resolving the matter before then, okay?
Thank you, Your Honor.
Thank you.
Have a good day. Good luck to you.
Thank you.
Mr. Brewer is here with Ms. Bowman. That case is scheduled at 1:45. Do the parties need to speak to one another, the attorneys?
Yeah, I'll be. Mr. Brewer is Miss Edmonds going to be joining us, or?
Yeah, we're still waiting for. Looks like our client is here. I'm still waiting for my partner, student attorney, and our supervising professor to join us. So
yeah,
we can wait until.
Mr. Brewer, what I will do is step off and do some other things, look at some possible jury trial dates for you. And when Ms. Edmonds appears, Marianne will get you into a breakout room. She'll let me know when you all are ready, okay?
Yeah, Your Honor, there won't
you.
actually be needing a jury trial as escrow has not been funded. I was gonna raise that at the beginning of the hearing. We can.
Then we'll take it up as soon as Ms. Edmonds gets here. Thank you.
Yeah, I'm gonna hop in the breakout room with my client, and then I'll come in and get Mr. Brewer and Miss Evans, whoever, in a few minutes.
Thank you, sir.
Okay, it'll actually be Professor Victoria Clark who will be supervising us. Ms. Edmonds won't be here. Just
Sounds
so you know.
good.
Thank you.
I'm a co-host. I'll find you. Thanks.
Thanks.
That's it.
This is 223369 LT, Park Estates versus Vanessa Bowman. May I have your appearances, please?
Robert Brewer on behalf of the defendant asking for permission to practice under Michigan Court Rule 8.120 under the supervision of Professor Mira Edmonds.
Request granted.
Thank you.
Today is the day and time set for the adjourned hearing in this matter. Mr. Brewer, Mr. Marks have had an opportunity to speak. How are we proceeding this afternoon, Mr. Marks?
Your Honor, we were unable to reach a settlement in this matter, so we'll have to probably set dates for trial.
How soon will you be prepared to try this case, Mr. Marks?
Mr. Brewer indicated a desire for discovery. I don't know if Your Honor would be ordering discovery at this time. I'll defer to you, but we would need some time.
Mr. Brewer?
Yeah, Your Honor, we would need, we believe we would need minimal discovery in this case, but there would be some questions. There are some questions outstanding as far as presence of management and communications about repairs that were and were not made that are central to our clients' counterclaims in this matter.
How long of a period of discovery are you looking for, Mr. Brewer?
Believe it would, depend on how long it would take to get those requests, but probably a month or two.
So 60 days discovery?
I think we could do something like 30 or 45, but 60 would be ideal.
I would
My
prefer
concern
6.
is-
I'm sorry, Your
Go
Honor.
ahead,
If-
Mr. Marks.
I would prefer 6. If we're going to do it, I would prefer 60, please.
I couldn't hear what you just said, Mr. Marks.
I said if we're doing discovery, I'd prefer at least 60 days.
60 days of discovery commencing today. And then after that discovery, are you anticipating some motions, Mr. Brewer
Yes, Your Honor.
and Mr. Marks?
Yeah, yes, we would like to resolve this case via motion if possible, for sure.
Let me go grab a couple of calendars for next year. Give me one moment, please. If discovery commences today and we're looking at 60 days, that puts us at January 30th or so. Then we're looking at motions. In February. I'm looking maybe at I can't believe I have to say this, a trial date, jury trial date of March the 24th. of 2023.
Your Honor, I don't mean to interject. There will not be a jury trial as escrow has not been paid pursuant to the
Your
court.
Honor, this matter is relating to the counterclaims and back rent, not as to possession. So a jury trial would still be fit under the rules.
What rule?
4.201H. The waiver of jury trial is only for the matter of possession, but as we've already agreed, the possession matter is mooted in this case.
When did we agree to that?
We've already noted the counsel and opposing counsel has agreed that the keys have been returned. Our client has vacated the apartment.
This is the first I'm hearing of it. That's why I said, when did we agree to this?
I apologize, Your Honor. I misspoke, but the issue that remains is for the money order, not for possession.
So we have a non-payment of rent case where the tenants, defendants, counter plaintiffs have vacated the property. So now the fight is just the unpaid rent that accrued and any abatement due to Ms. Bowman for the issues alleged in the counterclaim.
Correct.
Now I'm even more curious about the discovery if the Mr. Marks, your response to Mr. Brewer's assertion that the jury trial, right to jury trial continues, although the escrow has not been paid.
I think because of the fact that this case is originating as a possession case and the counterclaim, as you know, was filed as a result of that possession case, that the jury trial would be waived. I'd have to look into that further, Your Honor.
Mr. Marks, I'm looking at the court rule and I believe that Mr. Brewer is accurate. H2A3 indicates that if the defendant does not comply with the order, the defendant waives the right to a jury trial only as to the possession issue. And as Mr. Brewer has just indicated and you've confirmed, Ms. Bowman is no longer in possession of the property. So jury trial it is. As I was starting to say previously, we're looking at March the 24th, 2023. Would like the parties here at 8:30. The jury panel will be here at 9 o'clock so that we can dispose of any issues before the jury's arrival. I'm trying to back us into some other deadlines. If discovery is cut off at the end of January, we're looking potentially at February as a motion deadline. Motion hearing cutoff and final pretrial on February 24th, 2022. No, let me take that back. I'm sorry. February 21st, that's a Tuesday at 9 a.m. If any of these dates don't work for either you, Mr. Marks, or you, Mr. Brewer, and Professor Clark, please stop me and I'll make the adjustments.
Those work for us so far, Your Honor. Thank you.
Okay. So final pretrial motion hearing cutoff date, the February 21st, 2022 at 9 a.m. And we're doing the jury trial on the 24th. 2 weeks before that is March the 10th. the deadline for your witness exhibit and jury instructions, witness list, exhibit list, and jury proposed requested jury instructions on that March 10th, 2023. Anything else, Mr. Marks?
Just to clarify, Your Honor, we have a final pretrial on February 21st at 9 o'clock, and then another hearing on the 10th of March.
No,
sorry.
no hearing, just a deadline to file the paperwork necessary for the jury.
Appreciate it.
Anything else, Mr. Brewer?
No, Your Honor. Thank you.
Mr. Brewer, if you would draft the order with these deadlines and these next hearing dates, you can submit it pursuant to the 7-day rule. If the parties are able to talk and come to a resolution before your next appearance date, please contact my secretary and she can get a schedule before that next date.
Sounds good. Thank you, Your Honor.
Thank you, Your
You're so very welcome. Everyone have a good afternoon. Thank you for your patience today.
You as well. Thank you.
Thank you.